Good morning, and welcome to another installment of Bracewell's Environmental Webinar series. My name is Jeff Holmstead, and I'm a partner in the Washington, D.C. office, and I am joined this morning by my partner and friend, Brittany Pemberton. This morning, we'll be talking about EPA's long-awaited proposal to revoke the 2009 endangerment finding made by the Obama administration that greenhouse gas emissions from motor vehicles cause or contribute to air pollution, which may reasonably be anticipated to endanger public health or welfare. EPA published its proposal on August 1st. And for those of you who may be submitting comments, remember that the comment deadline is September 15th, so it's just a little bit over a month from now. I will say that this proposal came as no surprise. EPA Administrator Zeldin has said on more than one occasion that this is the most important step in his efforts to drive a dagger through the heart of climate change religion. And so what we've seen is the first step towards that effort. Just a quick reminder of the 2009 endangerment finding before I turn the time over to Brittany to talk about the proposal. The statutory language is up on your screen. The Obama administration basically made this finding in two steps. They first determined that a well-mixed group of 6 different air pollutants in the upper atmosphere are causing global climate change, which itself is causing a number of impacts that endanger public health or welfare. Having defined that as the air pollution that is anticipated to endanger public health or welfare, it was fairly easy for them to determine that motor vehicles collectively contributed to that air pollution. So that was the finding. It was specific to vehicle emissions. But the first part of that finding, that greenhouse gas emissions in the upper atmosphere represent air pollution that endangers public health or welfare, that part of the finding was also important to EPA's later findings for power plants, for methane emissions from oil and gas operations, and also from aircraft emissions. So that's the finding. And Brittany, tell us how EPA has proposed to revoke it.
So until it was released, there was, I think, pretty broad speculation that EPA's reconsideration of the finding would focus on things like the failure to consider downstream costs of regulations that would flow from the finding, and that EPA would spend a lot of time trying to refute the scientific record. The proposed rule does both of those things, but really an EPA's alternative proposal, which would repeal the finding on record and science-based grounds. I think myself included, among many, were surprised that this isn't EPA's lead approach and that EPA's lead rationale is actually much more nuanced. It's based on a clever and I think quite compelling reading of Clean Air Act Section 202A and some key Supreme Court cases issued since 2009 when the finding came out. EPA's main proposal is to repeal the endangerment finding because Section 202A doesn't authorize regulations based on global climate change concerns. Under this lead or the alternative proposal, that's that record or science-based repeal that I mentioned, EPA would be able to completely repeal all greenhouse gas regulations for cars and trucks. But even if the agency doesn't finalize either of those, it proposes to repeal the tailpipe regulations because the rules themselves are futile. That's a separate and sort of third approach that EPA has included in the proposal. That's based on its thinking that, domestic transportation emissions are really insignificant compared to global greenhouse gas emissions. I think EPA says if you add them all up, it's really about 2.5%. And EPA says that even if we reduced our domestic emissions all the way to zero, that would have no impact on global climate change. EPA also includes in the separate proposal some arguments that the tailpipe rules, increase the cost of new vehicles and slow fleet turnover, which leads to adverse impacts on consumers and air quality, and that those ultimately outweigh any benefits from the regulations. So under the lead rationale, EPA argues that the best reading of Section 202A is quite narrow, that the endangerment finding has to be focused on the direct impacts of air pollution based on local or regional exposure. The way EPA explains it is like this. The term air pollution, as used in Section 202A, is best read in context as referring to local or regional exposure to dangerous air pollution. And that's consistent with EPA's approach prior to 2009. And it fits pretty well in context. EPA in the proposal walks through the pollutants that Congress directed the agency to regulate under Section 202 and other parts of the Clean Air Act, and makes the point that all of these are of concern because of their effects at a local or regional level. In contrast, the endangerment finding asserted that 6 well-mixed greenhouse gases are air pollution, as Jeff explained, and that those would lead to increases in global temperature and change to ocean pH that in turn would then lead to environmental phenomena in combination with an open-ended universe of additional factors, which would potentially have adverse public health and welfare impacts on a varying severity in certain regions. So EPA really tries to show that there's a very attenuated chain of causation here when we're looking at what could be local emissions of greenhouse gases, but the way that the impacts are caused are just so much further removed. So that really helps them reach the ultimate conclusion that since greenhouse gases do not endanger public health or welfare through local or regional exposure to emissions, from cars and trucks, then this is not air pollution that can be regulated under Section 202. As you'll see on the slide here, EPA makes some other points like concern that the endangerment finding was made in an isolated way, separate from the cause or contribution finding that's required by the statute, and from the process of setting tailpipe emission standards. But I'm not sure that those are super persuasive. So, Jeff, do you want to take us through EPA's use of Supreme Court cases? I think they've done some pretty clever work here.
Yeah, let me start by just reiterating something you said at the outset, and that is that their primary proposal is really quite different from anything that they had been foreshadowing in their statements in the press. And I believe, as you said, that it is a pretty sophisticated legal argument that is certainly not only stronger than sort of their arguments in the press, but also very different and I think stronger than their proposal to repeal the endangerment finding for the power sector. One of the things that is kind of puzzling is that these two proposed reversals of endangerment findings are so different. It's almost as if they were written by a different group of people. And as I said, or as you mentioned, their primary proposal is really a legal interpretation of the statute that relies pretty heavily on several Supreme Court decisions that have come out since Massachusetts versus EPA and since EPA made the endangerment finding back in 2009. And I would say sort of the linchpin of this is the Supreme Court's holding in Utility Air Regulatory Group v. EPA, which everyone refers to as UARG. Folks may remember that when EPA did make the 2009 endangerment finding, at the same time, they issued the vehicle standards, and they also issued a rule called the tailoring rule. And the tailoring rule was necessary in EPA's view because under the PSD program of the Clean Air Act, which is sort of a subpart of the New Source Review program, all major sources of air pollution are required to get a PSD permit, which is a long and difficult process for industrial facilities. And the term major source is defined to mean any facility that has the potential to emit more than 250 tons per year of any regulated pollutant. EPA's conclusion was because they were regulating CO2 and other greenhouse gases from motor vehicles, CO2 became a regulated pollutant under the Clean Air Act, and therefore any source that emitted greater than 250 tons per year of CO2 would be a major source. The EPA recognized the problem with that, and that is there are hundreds of thousands of such sources. Most commercial buildings, hospitals, schools, even some large homes would emit more than 250 tons per year, and thus be major sources that would be required to get PSD permits for modifications or any new buildings of that type. That was completely untenable, and EPA basically said, well, because of the difference between CO2 and conventional pollutants, we, at least at the outset, are going to only look at major sources, which we would define as sources that emit more than 100,000 tons per year. The DC Circuit upheld the tailoring rule, as well as the endangerment finding, as well as the vehicle standards. Opponents appealed or tried to appeal to the Supreme Court, The Supreme Court declined to take a challenge to the endangerment finding or the vehicle rules, but they did accept the challenge to the tailoring rule. And they basically said that EPA could not simply change the major source threshold that was written into the statute, but they also said that the term air pollutant doesn't necessarily need to mean the same thing in all different sections of the Clean Air Act, and that EPA needs to read that term in the context of what Congress intended for specific sections. In Massachusetts versus EPA, the Supreme Court found that the broad term, sort of the broad definition of the term air pollutant in Section 302G is broad enough to include all greenhouse gas emissions. But the court said that the term air pollutant was clearly not intended to be coextensive with that because Congress didn't intend for EPA to be treating hundreds of thousands of non-industrial sources as major sources. So they said, for purposes of the PSD permitting program, the term air pollutant does not include CO2. In this most recent proposal, EPA has seized on that basically to say that the term air pollutant or air pollution doesn't mean the same thing in Section 202 as it might mean in the general definition of an air pollutant. And it needs to be read in the context of what Congress intended. And as Brittany explained, what they determined based on many years of EPA practice prior to 2009 was air pollution that was subject to regulation under Section 202 was only air pollution that causes local or regional effects when people are exposed directly to it. And they then went on to say that reading it any other way would implicate the major questions doctrine that the court hinted at in UARG and adopted sort of officially in the West Virginia case. So you may recall in that case, the Supreme Court emphasized that before a regulatory agency can take an action that has great political and economic significance, especially if it's a new use of a statutory authority, then they only have that authority if they can point to a clear statement by Congress that that's what they intended. EPA said under the major questions doctrine, there's no evidence that this is actually what Congress intended. And then they went on to say, furthermore, EPA's approach to regulating vehicle emissions, to regulating CO2 emissions, has prompted EPA essentially to mandate a shift from internal combustion engines to electric vehicles. And that's precisely the kind of shift from one technology to another that the Supreme Court said that EPA could not do in the West Virginia case. They go on to say that they believe that under Loper-Bright, that this interpretation is the best reading of the Act. And that's important because I think the reason that they have adopted this approach is not only to justify revoking the current standards, but trying to prevent future EPAs from regulating greenhouse gases under the Clean Air Act. I would say just a couple more things quickly. It certainly looks like this approach was designed to appeal to the Supreme Court. This court is quite different from the court that decided Massachusetts versus EPA. They certainly have seemed to be skeptical of EPA's ambitious regulatory agenda. And by adopting this approach, if the Supreme Court were to do so, they would essentially neuter Massachusetts versus EPA without actually having to overrule it. And they do emphasize that they are relying on Massachusetts and that this approach is consistent with it. So this is at the heart, I think, of their efforts not only to revoke standards, greenhouse gas emission standards for vehicles, but also to prevent future EPAs from coming back and regulating CO2 under the Clean Air Act.
I think what's also interesting about this strategy is that they seem to have chosen sort of the better fight to have. I think by kind of downplaying arguments that they might make about what's wrong with the scientific record in their view back in 2009 or how the science has evolved and might cast light now on the conclusions that they made in 2009 with the record that they had. they have, I think, avoided sort of a trickier legal situation. The DC Circuit and other courts give EPA extreme deference on technical and scientific determinations. But even still, it might be quite difficult to get that court or even the Supreme Court to agree that EPA has the science right this time but didn't in 2009. So focusing on statutory interpretation and bolstering that with these Supreme Court cases, I think would allow the Supreme Court to avoid that fight. And it helps with the point that you made so well, Jeff, which is that they're really trying to do this in a durable way. If they led with these science and record-based arguments, I think that would allow a future administration to come along and redo the finding and come out the other way on the science again down the road. And by focusing on statutory interpretation, they've increased their odds that can't happen.
Yeah, and I also want to be clear that although this is I think a very clever and sophisticated legal argument, there are certainly arguments on the other side, and we will hear those during the comment period and certainly during, assuming they finalize this, certainly during the litigation to follow. As environmental groups have pointed out in the press, the Supreme Court in Massachusetts versus EPA certainly seemed to believe that if EPA made the endangerment finding, then that would result in regulations. And even maybe with the UARC case, where the court said that air pollutants were not, or greenhouse gas emissions were not air pollutants for determining major source thresholds, that in certain cases, those pollutants could be regulated by requiring companies to get back limits in their PSD permits. So again, there are certainly arguments on the other side, but I would say this is more than a plausible argument, and it is an argument that could certainly appeal to the Supreme Court. I suspect, knowing what we do about the DC Circuit, which will get the case first, that they may be disinclined to adopt this. And I think that's also important as we look at the timing of the litigation that's likely to follow. That I think that EPA and this administration is hoping or believing that their best chance is to get this argument before the Supreme Court.
Yeah, that makes a lot of sense. So switching gears, we wanted to talk a little bit about the implications of the proposed repeal of the endangerment finding. One thing that's also pretty interesting about all of this is sort of the order of operations. EPA proposed first to repeal the Section 111 greenhouse gas standards, for power plants, and that is sort of a multi-pronged approach as well, with a full repeal and then a more narrow approach. And then it came along with the endangerment finding proposal that we're talking about today. It's not really clear why they went with the order that they did, except perhaps, as press has reported that there, may have been different authors involved in these two proposals. But I think it opens up some interesting questions about what EPA may do next for the Section 111 greenhouse gas proposal. Arguably, some of the legal interpretations that we've been talking about here around Section 202 could also apply to Section 111, which means they could be used to support a conclusion that EPA doesn't have the authority to regulate greenhouse gases under that section either. That would obviously bolster ongoing efforts to repeal those regulations for power plants. And it could be used as a key rationale if there's a future proposal to repeal the oil and gas methane rules, the so-called Quad O, A, B, and C NSPS. Prior administrations, and Jeff alluded to this at the beginning, relied heavily on the endangerment finding and issuing greenhouse gas regulations under Section 111. And it was incorporated into the power plant and those oil and gas methane rules. So, even though revoking this finding now is not, sufficient, it's not the only thing you need to do to invalidate those other rules, finalizing the endangerment finding repeal would eliminate a key part of the rationale for those regulations. EPA will have to take separate rulemaking steps to repeal the Section 111 standards, but there's certainly a legal impact from undoing the endangerment finding. Those separate steps, as we've mentioned already, are in progress on the power plant side. And so it opens up the question of, will EPA take additional steps on that docket? The comment period closed last week on the 7th. It's possible that we'll see a supplemental proposal from the agency that either addresses some of these legal issues and explains how they would apply, to Section 111 and asks for comment on that. But at the very least, I would think EPA would want to shore up the record and explain the impacts of this repeal, just in terms of, the reliance in the past under Section 111 on this endangerment finding. If I were EPA, I certainly would want to do more to ensure the success of that full repeal on the power plant side. So I think we will see what happens next on that. EPA hasn't gone so far with the oil and gas industry just yet. The agency proposed in March, or announced, I guess, in March, as part of the 31 deregulatory actions on March 12th, that it would reconsider the oil and gas methane rules. We don't really know what that might look like yet. The agency has already granted industry petitions for reconsideration on a couple of technical issues that are really related to flaring. But there are other concerns raised in those petitions and in ongoing litigation over the methane rules that the agency has yet to address. So reconsideration could be the type of full repeal that we've seen with vehicles and now with power plants, or it could be something more tailored to resolve some of the bigger concerns, just from a technical perspective. EPA also put out in recent weeks an interim final rule to extend a bunch of deadlines in that rule. So I think that buys the agency some time to kind of figure out its approach. A full repeal also raises some complex issues that the agency would have to think through. During its first 4 years in office, the Trump administration repealed methane standards in the oil and gas industry, but that rule was later revoked by a Congressional Review Act resolution. EPA's range of motion to revoke methane standards again is, I think, unknown in light of that congressional action. And the other thing that's, I think, different when we think about these using Section 111 to regulate the oil and gas industry is that the agency has acknowledged that requirements that reduce VOCs from oil and gas result in greenhouse gas reductions alongside. So it's possible that even with a full repeal, another administration could look to further VOC reductions to get the same results as the methane rule without regulating methane directly. So some interesting issues that they'll have to think through.
Yeah, and if I could just make a couple of observations about all of those things. One of the things that I think should be noted is major industry groups have not been pushing EPA to repeal or revoke the endangerment finding. It has been interesting to see statements from the trade associations representing the auto industry, as well as some automakers who have suggested that they would prefer durable, reasonable standards as opposed to a revocation of the endangerment finding. And we've even seen that, I think, from the American Petroleum Institute. So this proposal, I think, it puts industry in a tough spot in some ways because they do believe that the Obama standards are unachievable, and even if they were achievable, would be enormously costly. So they would like to have the regulatory relief, but I think there's some concern that revoking the endangerment finding is not the best way to do it. It does potentially put both the automakers and the utilities in a tough spot, because if they repeal the power plant standards and repeal the vehicle standards based on revoking the 2009 endangerment finding and then the later endangerment finding for power plants, and that is not upheld in court, then the Biden regulations would spring back into place in some fashion. Now, EPA would have to do further rulemaking to sort of adjust the compliance deadlines, but if EPA really does choose sort of an all or nothing approach, then there is that risk for industry that even though there are strong technical and legal reasons to revoke or to revise the standards themselves, those may not have been addressed in any EPA rules, and those Biden rules could spring back into place.
In addition to impacts to regulations under Section 111, the endangerment finding repeal probably has stationary source permitting implications. Once all greenhouse gas emission standards have been revoked, including aircraft standards, in addition to regulations for cars and trucks and power plants and oil and gas sources that we've been talking about today, greenhouse gases would cease to be a pollutant that's, quote, subject to regulation under the Clean Air Act. So that would remove the trigger for imposing greenhouse gas air permitting on stationary sources under the PSD and the Title V programs.
One other thing I wanted to mention just quickly, and this is a topic that we could spend a full webinar discussing, and that is another Supreme Court called American Electric Power versus Connecticut, or AEP versus Connecticut. That was the case that postdated Massachusetts versus EPA, where a number of states had sued major utility companies under federal common law in an effort to get the courts to impose limits on their greenhouse gas emissions and also potentially seek damages for those emissions. In the AEP case, the Supreme Court unanimously, in a 9-0 decision, said that the Clean Air Act displaced any sort of common law remedy. And even though the court said it was not specifically addressing state common law, that case and that basic idea that the Clean Air Act was meant to displace common law remedies has sort of been the leading argument that companies have made in response to some of these tort suits. EPA does address that in its proposal, and they take the position that even with the repeal of the endangerment finding, the federal common law would be displaced. That certainly is consistent with a statement in the AEP case, but I think there is concern that it certainly weakens that argument and potentially, especially when it comes to state common law. Again, without going into all the case law on those issues, I would say that is a concern that some people have that is worth thinking about. And then finally, I do want to come back to something we mentioned earlier, and that is just the timing of all of this. A 45-day comment period is extremely short for a proposal of this magnitude, but the administration has made it clear they're not planning to extend that comment period as they did with the 45-day comment period for the power plant rule. We are hearing that they're planning to finalize the rule by the end of the year. Again, that would be, sort of a record for this type of a proposal. But I think the thinking that goes into that is they certainly want to be in office in order to defend this rule all the way to the Supreme Court. It's always a little tricky to predict how long the legal process will take, but from the time a rule is finalized until the DC Circuit reaches a decision on it can easily be 18 months, maybe a little shorter than that if the parties agree to shorter deadlines. And then if the DC Circuit were to strike down the repeal of the endangerment finding or for either power plants or for vehicles, the administration would certainly seek review in the Supreme Court. And that could easily take another 18 months. So the timing is tight if this litigation goes all the way to the Supreme Court. And that's obviously why the administration is pushing so quickly to get this rule, which, as I say, is at the heart of their efforts to drive a dagger through the heart of climate change religion. So I think we will be seeing a final rule in quick order. We've talked very quickly about a lot of issues. There are more things we can talk about, but I think we've at least given you a taste of all of those. And we thank you for spending some time with us this morning. If you have questions, please feel free to reach out to either Brittany or me or any other member of the Environment, Lands, and Resources group in Bracewell. And thanks again.